Debate, the Honourable Member for Toronto, Danforth.
Monsieur le Président.
Mr. Speaker, I rise today to speak to Bill C-14, Medical Assistance in Dying. This is not the first time I have had the honour to participate in the discussion of this matter as a Member of Parliament. I was also a member of the Special Joint Committee on Physician-Assisted Dying. As a member of that committee, I was able to hear the thoughts of many people, both in my riding of Toronto Danforth and across the country, on this very important issue that affects us all, our end-of-life care.
Would have been for a bill that would have allowed for a broader scope of application. But I support this legislation because it is a first step in the right direction, and there is a commitment to study the important issues of age, mental health, and advanced directives. As will become apparent as I speak further, we need to take this first step because this file has been left to languish for too long. My step would have been a bit bigger, but I'm ready to start here on this path of incremental change. Mr. Speaker, I intend to share my time with the member from Hamilton West, Ancaster Dundas. Jusqu'à maintenant, la question était de savoir.
Until this time, the issue was going to be whether we were going to deal with medical assistance in dying, but today we're struggling with another issue, which is to know whether or not we're going to allow the right to such assistance. Today we are faced with a different question, because following the Supreme Court of Canada decision in Carter, the medical aid in dying needs to be decided by June the 6th. And the thing with this bill is that we have the opportunity to create a federal system to help medical assistance in dying.
Commission of Canada reported on euthanasia, aiding suicide, and cessation of treatment. It found three basic principles reflected in our law, and I find that these principles set a good basis for our debate. 1, the protection of human life is a fundamental value. 2, patients have the right to autonomy and self-determination in making decisions about their medical care. And 3, human life needs to be considered from a quantitative and qualitative perspective. I find it particularly instructive that the second principle creates a basis for a patient-centered approach to medical assistance in dying. This was the approach adopted by the Special Joint Committee on Physician-Assisted Dying, on which I served. Looking at the history of this issue, I've traced a long path of private members' bills, Senate bills, and private motions in this House. The issue has been before us approximately 11 times since 1991. The list of past attempts on this issue is incredible and demonstrates that efforts that have been made to grapple unsuccessfully with this issue have continued for too long. It is why I find it so important for this House to cross over this impasse and to take the first step towards legislating a framework. The issue has not only been before us here. The other place has also considered the matter in committees, subcommittees, and bills. Just over 20 years ago, the Special Senate Committee on Euthanasia and Assisted Suicide released their report of life and death. L'objectif de ce comité.
The goal of this committee was to set the stage for the full and open national debate that would take place in the coming months and years. The majority of the senators on the committee were not ready to support medical assistance in dying. The minority made recommendations that would include allowing medical assistance in dying for an individual who was competent and suffering from an irreversible illness that had reached an intolerable stage as certified by medical practitioners.
I finished reading the book by the Honourable Mr. Stephen Fletcher, Master of My Fate, which outlines his experience as a parliamentarian generally, but focuses on private members' bills that he brought on the issue of medical assistance in dying. The book brought special insight into his journey on this question. He shared his story of the massive accident that rendered him quadriplegic and his election to this House, including the time he served as a cabinet minister. Our most recent initiative in this House on the issue of medical assistance in dying was 2 connected private members' bills put forth by the Honourable Mr. Fletcher. The first, Bill C-581, proposed to amend the criminal code to permit a doctor to assist a person in taking their own life. The eligibility criteria proposed in this bill would track the language of Carter very closely. I'll read the most salient eligibility criterion for the sake of this House. The person must have been diagnosed by a physician as having an illness, a disease, or a disability, including disability arising from a traumatic injury, that causes physical or psychological suffering that is intolerable to that person and it cannot be alleviated by any medical treatment acceptable to that person, or the person must be in a state of weakening capacities with no chance of improvement. His other initiative, Bill C-582, proposed to establish a Canadian Commission on Physician-Assisted Death, which would have collected data from physicians who performed physician-assisted death. It recognized the possibility for incremental steps. The bills were read a first time and left to languish on the order paper, but on December 2nd, 2014, similar legislation was introduced in the other place and was debated on 7 occasions, as late as June 2nd, 2015. As we all know, Mr. Speaker, during that time frame of December 2nd, 2014 to June 2nd, 2015, the Carter decision was released. Il est également intéressant.
It is also worth noting that there have been active discussions in our provinces and territories about a framework for medical assistance in dying. The most notable example is Quebec, which struck a committee in 2009 to develop legislation on medical assistance in dying. The legislation came into effect in December 2015. Much has been said regarding that law, and I won't repeat it, but it's notable that they, too, have a terminality provision. I found it interesting that in testimony before our committee, Maître Jean-Pierre Ménard of the Barreau du Québec stated that he believed the terminality clause of the Quebec legislation would have to be removed in light of the Carter decision. It underscores the point that such legislation will develop through incremental changes. It was a tremendous experience to work alongside senators and veterans on the Special Joint Committee. It was the first Special Joint Committee in about 20 years, and I see a strong value to this form of committee on major issues. The witness testimony and thoughtful submissions gave a strong base upon which to form our recommendations. I stand behind the recommendations that we made. We did not come to our decisions easily. We debated, lost sleep, and worked together through the recommendations.
How then does my background on this file inform my views of the legislation we are debating today? I would have preferred that it would be broader. Most of what I've heard from my own constituents favors a broader approach. But this bill is a first step into a complicated matter. We need to empower individuals to choose how to manage the end of their lives and give value to the Law Reform Commission's idea of patient-centered approach. And we need to consider not only the quantity of life, but quality. We need to respect people's autonomy and the right to be free from suffering without putting vulnerable Canadians at risk. This legislation gets us much closer to that goal than we currently find ourselves. I would have preferred that we would remove the clause of reasonable natural death, which refers to the foreseeability of a natural death. It's a terminality clause of sorts, and this clause is vague and could place an overbroad restriction on a sick person's right to be free from pain and suffering. The concern about this terminology, for me, is that it tends to devalue the lives of the oldest among us. They are the most likely to be given permission to seek medical assistance in death with the legislation, in my opinion. The young and sick suffer as much as the elderly. And to quote Stephen Fletcher, if the person is a cognitive adult, why on earth would we impose our views on what the quality of life is? The lack of advanced directives in the legislation is also too restrictive. A fundamental point of the Carter decision was that the Supreme Court of Canada had found a violation of life, liberty, and security of the person if individuals would feel like they would have to cut their lives short because they did not have an expectation that they could end it later when the time would come. It's a tricky issue, but I'm happy to see a commitment to study this issue further. In my opinion, Mr. Speaker, the positives of this bill do outnumber the negatives. So I will be supporting this bill. but I do see it as a first step on the journey. Thank you.
Question commentaire, questions and comments. The honourable member for Kitchener-Conestoga.
Thank you, Mr. Speaker. I want to thank my colleague for her intervention today and also for her service on the Joint Parliamentary Committee that studied physician-assisted dying. Mr. Speaker, my colleague referred many times to my former colleague, Stephen Fletcher, who appeared before the committee, and I've had many conversations with him, and I understand his position. However, my concern is that had Mr. Fletcher had access to physician-assisted suicide back the years ago when his accident first occurred, he very well may have followed through. And Mr. Speaker, that would have been a huge loss for Canada, for his family. And my concern is that when we implement these kinds of decisions, there's always the risk of one person inadvertently terminating their life. That would be a huge loss. We no longer practice capital punishment in Canada, Mr. Speaker, and one of the reasons is it's too great of a risk that one innocent person would die. So my question to my colleague is, how would she ensure that someone like Mr. Fletcher, who in a time of deep depression, deep physical suffering, may have taken a choice that would have hurt him and hurt all of Canada because of the loss of his life and his contribution to this country? Thank you, Mr. Speaker.
The honourable member for Toronto Danforth.
Mr. Speaker, I would rather not speak about an individual specifically when I respond to my friend's question, just because I cannot predict how his decisions may have not been done, what he would have decided if this legislation had been in place. But to speak more generally, I understand the point that he is raising, and that was my friend is raising, and it was a question that was of a concern to me in the committee as well when we were examining the issue of what about a person who suffers a traumatic injury and is faced with a change of circumstances, and how would they have to handle these types of decisions? We did hear evidence before our committee on that issue, I think especially from Professor Jocelyn Downey, but that's what stands out in my mind. On the question that when we're talking about irremediable as part of the determination and competence and the assessment of competence, a person right after a traumatic injury may not, in a medical opinion, be found to be in an irremediable state or able to make the competence test, because they would be in a state of flux at that moment. But that's something that we need to look at further. That's just something that we heard in our evidence. It was one position, and that's why I'm so happy that we're committed to look further at the issues and discuss it further, because it is an important question.
Question et commentaire, questions and comments. The honourable member for Timmins, James Bay.
Thank you, Mr. Speaker. I want to thank my honourable colleague for her speech. This is an issue that affects all of us, and we respect the very personal views that are brought forward. What concerns me in the legislation that has been put before us by the Supreme Court is that we are not talking about an overall balance in end-of-life choices. We are talking about the very specific responses to the Carter decision. Whereas 80% of Canadians don't have access to quality palliative care across this country. So 80% of Canadians facing end of life and their families don't have the choices about what good quality end of life care for themselves and for their families. So in this vacuum, there must be a commitment by the federal government, but we haven't seen that. We saw $0 in the budget for palliative care. Now, the New Democrats have motion 4-6 before the House about moving forward on a palliative care strategy, but also taking responsibilities for areas under federal jurisdiction. The federal government plays a huge role in the delivery of health services, and they deny palliative care services often. And issues in terms of changing the EI provisions to help families. So I'd like to ask my honourable colleague, where is this government's commitment to the larger discussion on end of life that Canadians really need to be engaged in?
The honourable member for Toronto Danforth.
Mr. Speaker, I thank my colleague for that question. Palliative care is an important part of the discussion about end-of-life care. There's no question it's come up several times in this place as we have discussed it, and it is an important part. I'm a little bit wary of throwing around percentages and numbers. When we were in committee, we heard a lot of different percentages, and in fact, perhaps it's that we do not have a fulsome understanding at this moment about what access to palliative care truly is. So that is something that needs further examination as well. So on the numbers, I'm a little concerned about percentages. But it is, what my understanding is from what we heard and read before the committee, is that jurisdictions that have introduced medical assistance in dying have actually increased their access to palliative care at the same time and the quality of that care.